Nothing further.
All right, thank you, counsel. Appreciate your arguments. The court will call on to be heard at this time Harper Mechanical versus Hunt Construction Group et al.
Good morning. May it please the court. My name is Jamie Galati Moses from Fisher Rushmer in Orlando. I am here on behalf of the appellant, Harper Mechanical, LLC. At counsel's table with me is Martin A. Kaiser, the general counsel for Limbaugh, the parent corporation of Harper. I would like to reserve 5 minutes for rebuttal. Thank you. This case comes down to one issue in a nutshell.
Let me just ask you a question about jurisdiction.
Yes, sir.
To begin with. The surety's out, right?
The order was final with respect to the surety,
Okay.
as stated by Judge Roche.
But the general contractor is still in, right?
Because the general contractor still has outstanding claims against us.
It's a counterclaim, but it arises from the same contract, right?
Yes, sir.
Okay, so any order with respect to the general contractor is not final, right?
No, Your Honor, but they have agreed that this issue, as it applies to the surety, would apply to them as well.
Well, you say this issue, there's a couple of issues. One of the issues is the amendment of the complaint,
Correct.
right? And as I understand it, that proposed amendment would have been to assert two claims, one for failure to distribute the settlement and the other for something called constructive trust. Both of those were proposed as to the general contractor, right?
Yes, sir.
How can we address that issue on appeal?
I think you can, because they were wrong, number one.
Well, but I mean, nobody can confer jurisdiction on the court. You know that, Ms. Moses. So how do we have jurisdiction to address that?
Because, boy, you threw me for a loop.
I'm sorry, and I really don't mean to do that. And we would have given you a heads up on that had I had my head into the case.
No, it's not your obligation to do that. I understand. We have been operating under the assumption it was not raised in the appellee's brief that this was an issue that could not be considered.
No, the court raises jurisdiction all the time.
I know.
Sua sponte.
I know, Your Honor. We would appreciate if you would consider those issues, because in the event you were to reverse
We want to so bad. But if we are powerless to do that, we are powerless to do it. And that's what I need you to explain to me, how we have the power to address that issue as to the general contractor.
Well, if I must be candid with the court, the final order on the appeal is related to the effect of the partial waiver and not the trial court's denial of the motion for leave to amend to file the third amended complaint.
Okay.
I do believe you can consider, however, the second abuse of discretion that we have raised with respect to the trial court's denial of our request for leave to amend our reply, because she did say, the trial court did say it affected her analysis. So I do believe that
the reply was directed to the release defense, which
Yes,
would
sir.
have pertained to both defendants, right?
Yes, sir. But if we properly did not raise a reply and the surety gets out for our failure to do so, I do believe you can address
hear
that.
that issue, yeah.
Okay. So we can address two of the three issues?
Sure.
Fabulous. May I proceed?
Sure.
Okay. The main issue in this case is whether this document, a form document required by Hunt for Harper to execute in order to obtain a progress payment through years of construction, constitutes a final waiver sufficient to trump an extensive trade contract agreement between these parties, 29 change orders that specifically detailed a final reconciliation of accounts owed to be made, the course and dealings of the parties and how they themselves treated this form, the admitted intentions of the parties, and their own construction manager, Robert May, admitted this was never intended to act as a final waiver and that the monies owed to Harper were always paid when they should have been, despite the execution of these documents. Nevertheless, the trial court determined that this one little form, out of hundreds of pages executed between these parties, was unambiguous, was a standalone document, and therefore it completely barred Harper's claims.
Let me ask you a couple questions about the release. If it doesn't mean what it says, if it doesn't mean that upon payment of a specified amount of consideration that the subcontractor is extinguishing its claims, releasing its claims, what would have been the purpose for this document?
In all candor, if the way these projects work, this was how Harper was to get paid on the work. Now, this project, as alleged in the complaint...
So they were extorted into signing the document?
I won't go so far as to say extorted, Your Honor, but it is a course of conduct with these parties. Right. You're due for a progress payment.
I mean, we have to... The law has to presume that, there's some purpose for a document that parties execute. And, everybody's got unequal bargaining position in these commercial relationships, and I'm certainly appreciative of the realities of the fact that to get a draw you got to sign something, but when you sign something to get a draw, I guess you have to assume that it means something. Well, and my question to you is, if it doesn't mean what it says, what does it mean?
Well, Your Honor, number one, let's look at the document itself. Just the one page itself says it's effective as
it's one page, Ms.
Correct.
Moses, but I'll tell you, it's got a lot of words in it, and
Correct.
It's very broadly drafted.
But let's just look at a few of those words,
okay, keeping
in mind that this document must be construed against Hunt. That's the law in Florida. It drafted it. It's chosen language. It gets drafted.
If there's an ambiguity in it, right?
Yes.
Okay. Tell me where the ambiguity is.
It's effective as of February 25th, 2004. It is signed May 3rd, 2004. The payment application that it references says that it's effective November 1st of 2003 through February 25th of 2004. It encompasses a change order that doesn't even fall within that period. Change order 29 is dated March of 2004. Change order 29 calls for a final reconciliation, and it is not encompassed in this document. But the trial court said it was. I wish the trial court had gone so far to even do this analysis. All that the trial court focused upon...
Did the change order precede the execution of the last release? Did the execution of the change order precede the... My understanding is that the last release was signed in 04, right?
Yes, sir.
Was it May or February?
May.
May of 04. Wasn't all of the didn't all of the performance precede the execution of that release?
Yes, Your Honor, but this
why wasn't that the final reconciliation of all matters between these parties?
Okay, number one, the change order that it supposedly includes is submitted afterwards. It calls for a final reconciliation that has not been done. Number two, there's a $100 retainage.
I asked you, so you're saying that the change order was executed after the May release?
No, not executed, Your Honor, but it's effective after. It's a March change order, and this document is only effective to February 25th. Mm-hmm. And it says that. Further states, as of February 25th. We've got a March change order. That March change order is not effective on February 25th. There's a $100 retainage. Standard in the industry, when you're settling up your issues with a contractor, you zero out the retainage. They left a $100 retainage because there were so many issues left to resolve between these parties, and they weren't resolved. Plus, Your Honor,
what about the notice of claim requirement in the contract? That it appears undisputed that your client did not ever timely, in accordance with the contract requirements, file a notice of claim for any of the matters that you're now suing.
Your Honor, I would
contractor.
submit if we're having this discussion, we are so far beyond summary judgment that it just demonstrates why this isn't appropriate. This was not an issue down below. This was an issue raised in Appellee's brief. The trial court did not consider a failure to give a notice, and if they did, she didn't articulate it. And I can see Ms. Womble shaking her head.
Was that
so maybe
not
she
a
did.
basis for the motion for summary judgment as well? Wasn't the notice of claim language part of the basis for requesting summary judgment?
It was mentioned. It wasn't discussed by the trial court. I do
No,
not
I'm talking
believe-
about the motion for summary judgment.
Yes.
Okay.
Yes.
And in response, did you file anything that showed that there was an issue of material fact as to whether or not you filed a timely notice of claim in accordance with the contract requirement?
Your Honor, the facts demonstrated that Hunt and Harper were negotiating these claims continuously before the execution of this document. Hunt used our claim to make a claim to Orange County. Orange County acknowledges that Harper had a mechanical work claim on this project.
I guess what I'm asking is, in response to the motion for summary judgment, when they said that Harper never filed a notice of claim in accordance with this contract requirement, that you said, here was our notice of claim, it was timely.
Your Honor, I do not believe, and my general counsel will let me know and I will bring it up on rebuttal if I am wrong, but I do not believe we did not submit the form notice of claim. But the notice of our claim was there and admitted by Hunt. I mean, the claim that came a year and a half or so after the release was signed and after the end, that's the claim you're talking about? Well, Your Honor, this project, the maximum price was never decided because the documents were not concluded. There were continuing negotiations throughout this project to resolve what Harper would eventually be owed, and they couldn't. So both parties, I guess mistakenly, continued to work with each other and submit change orders and then payment applications, and they would be paid.
I guess I'm troubled. I mean, it's troubling to have documents that are perfectly crystal clear, appear to be, in terms of notice of claim and releases and things like that. And basically the argument is the contracts don't matter at all. The language doesn't matter at all. Nothing matters in terms of what we signed and agreed to.
Your Honor,
that seems to be the argument.
If you believe that the trade contract agreement is crystal clear, then this summary judgment must be reversed, because this form references the underlying contract between the parties. The underlying contract between the parties provides in paragraph 5.2b that the final reconciliation of what is owed on this property will be done a certain way and through the submission of certain forms. And that was not done. And the reason why it wasn't done is because these parties were continually negotiating what was owed on this project as a result of the contract documents not being completed at the time of the contract. So if the trade contract agreement is as crystal clear as you say, then there's no way the trial court could have entered summary judgment and found this partial waiver, which is ambiguous on its face.
Where's the ambiguity in the document?
Again, the effective date of February 25th, and it references specifically a payment application that has an effective date through February 25th, and it specifically references a change order that's not even effective until after the fact. Okay? It also leaves a $100 retainage, but it's being used, and it says it's a partial waiver, and it's being interpreted as a final waiver. This is a form that was not negotiated. Harper did not get to accept anything out of this. There is no place on this form to accept anything. And the suggestion is...
This poses all those arguments. I mean, about, who, whether they should, either they're bound by it or they're not, aren't they? I mean, whether they had an opportunity to cross things out. I mean, I don't understand the legal significance of that.
The legal significance is the case law cited by the trial court in support of her finding does refer to cases in which there was an opportunity to write an exception in. But, Your Honor, all of this just demonstrates, in my humble opinion, that there was a latent ambiguity with this document, and extrinsic evidence should have been considered by the trial court. And there's clearly questions of fact on all of these issues. You may not ultimately agree with the argument I'm making here. The judge may not later either, but there were enough fact issues on all of these issues.
All right, let me ask you a couple of questions about some of these legal concepts. Waiver, which was what you wanted to amend your reply to state. How would waiver operate with regard to the last release?
Your Honor, let me back up. It was not our position that we had to amend.
Okay.
But when the judge says to us...
Just assume waiver is an issue. Tell me how it operates. Tell me how it works.
Because if this document truly says what Hunt says it does, which we dispute, they waived that.
Isn't waiver something that happens after the execution of a document?
Right, and it was our position throughout this. 31 of these were executed, and payments were made.
I'm talking about the last one, though. What did they, in other words, you got 10 releases in succession. If they waive by making a payment over release number 2, does that mean that that operates as a waiver as to releases 3, 4, 5, 6, 7,
Here's
8,
how
9,
they did,
10?
Your Honor. They waived it by continuing to negotiate with us to resolve this thing. There were ongoing discussions. There were mediations I can't talk about. There was a claim made to Orange County based upon our claim. If our claim was completely waived, why did Orange County pay them $14 million? And why did the design professionals, errors and omissions insurance, pay them additional 10 more? If this thing was an iron
I thought
plan,
your waiver claim was predicated upon the fact that they paid change orders that preceded the execution of releases.
Your Honor, again, I must stress, we didn't believe we had to assert a waiver claim. All we've ever said is that,
Well, do you have a waiver claim or not?
Well, the trial court felt we had to have a waiver claim. That's why we tried to amend it.
Are you asserting that you have a waiver claim?
I think you can argue it, that and estoppel. I think you could argue it. But, and I'm running out of my time, but Mr. May testified, and he's the construction manager for Hunt, that, oh my gosh, I just lost my thought. And I can't even finish it, and I apologize.
I'll give you a couple of Ms. Lippincott's minutes.
Thank you.
She didn't use all hers.
Okay. Thank you, Marcia, when she comes back.
Mr. Main, who's the Hunt construction manager, you were saying.
Yes, and you know, he testified. Now I'm on track. He was asked about correspondence that he had written to Orange County requesting additional funding. And in that correspondence, he says, our sub HARPER is doing work without even a change order because we've asked them to and they're doing it. So we did so much extra work on this project that we were led to believe we would be compensated for. And we weren't. All of a sudden, this document is thrown in our face as a final waiver, which was never intended to be a final waiver. It's one document of many, and under the, the integration rule, if a document purports to be part of another, then those documents have to be construed together. And our trade contract agreement completely details how final payment will be made on this case. 9 of our 29 change orders say there will be a final reconciliation of the amounts owed. We have Mr. May testify. We never treated these as final waivers.
Does the doctrine of course of performance or course of dealing, is that a document, or is that a doctrine that may be used to vary the terms of an unambiguous contract?
Yes, it may.
If that conflicts with an unambiguous contract, you're saying that the court can follow the course of performance or interpret the document to
Yes, I
include
do.
the course of performance.
Yes, I do.
What's your authority for that?
The case law we have cited in our brief, for example, if the parties have orally modified a contract, you all, forgive me, this court in 2007 in the Lake Sioux case reversed a case based upon an unambiguous document and determined that there was a question of fact as to whether the parties had modified that document. The Hurt versus Leatherby case out of the Supreme Court in 1980 says that you have to look at the course and dealings of the parties and the other things they did. Now, Your Honors,
But that doctrine pertains to conduct subsequent to the execution of the contract, right? It's called course of performance, right?
Well, I was dealing with course of dealings, which you had also
I think
referenced.
they're the same, but
And Your Honor, I would say the negotiations afterwards, if Hunt truly had thought this was a final waiver, there wouldn't have been discussions, and there would have been no submission of a claim to Orange County, and the receipt of $14 million from Orange County and $10 million from the design professionals. Obviously, there was an effort to act upon our request for payment that was owed on this project. And that's course of performance then afterwards.
I don't understand that as a legal argument, because even if there was a full release, if you get sued, you're going to have to deal with the suit. If you get a claim, you're going to have to deal with it. You're not going to just say, I'm not talking to you. The fact that they dealt with what you sent them after this project was completed, I don't understand how that legally means that a release isn't a release.
Okay, that you're assuming it was a final release executed.
I mean, that's the argument. So.
Okay. Well, and it wasn't a final release, number one. Number two, there's a latent ambiguity in it. And number three, the trial court didn't even go into this analysis, which is why this order must be reversed. If you look at Judge Roche's order, all she said was any and all, those three words, are the most universally unambiguous words in society, and this is a standalone document and my hands are tied. And she's wrong. She is absolutely wrong. This is a document which is one of many. May I go on, Your Honor? I think Marcia had 6 minutes and 22 seconds left.
I'm just going to see where you end up and decide at that point what's fair for rebuttals. So.
Okay. This doesn't normally happen. But the problem was that she wouldn't even consider any latent evidence. Everything, or extrinsic evidence to prove a latent ambiguity. Every case she relied upon is a single standalone document between the parties. In the Sir Linnea case, I can't pronounce it, but out of the Florida Supreme Court, that was an MSA that the wife challenged. In the Hold versus Manzini case, I believe out of the 4th District, that was a settlement agreement over a malpractice claim that the party challenged. In all the other cases relied upon, it was a singular document entered into by the parties, and someone wanted to change a term later. The Bill Hurd case versus Chevrolet, they didn't want the arbitration provision. That bothered the parties. They had said if we just read it, we wouldn't have agreed to it. And the court said no, because that was a single standalone document that the court interpreted to be clear. We have a single form that on its face, in my humble opinion, raises questions to begin with. It references a contract agreement that provides for something different than how this form is being interpreted. It references change orders, and it says all change orders are to be considered in conjunction with this document. 9 of them have final reconciliation language. We presented course of dealings, course of performance evidence. We presented the intent of the parties.
All right, let's go ahead and save you some rebuttal time. We'll add 5 minutes total. Judge Griffin, you have a question?
Unfortunately, I have another question.
Yes, ma'am.
I don't want to use
I'll
up your
yield to Judge
rebuttal
Griffin.
time, but explain to me what the number 34,263,704 means. What is that number?
That is what we were actually paid.
That is
Our
what
claim
you
is in excess of that.
Where does that number come from? What does it consist of?
Extra payments as a result of the significant change in the plans and the increase of our costs. And that money was paid to Hunt by Orange County.
Contract price plus change orders, right?
Correct.
And that was about $10 million in changes?
Well, and there's also a fee that could be included. We never eventually settled on the maximum price, because the maximum price of $24,900 was established without the documents being completed. And then when they were completed, the price, it was unbelievable. And there was a deadline because the convention center, or Orange County, had made commitments to other parties to use the convention center, and therefore there was overtime, there was extra work, and those were our increased costs. This claim is about increased costs above and beyond that $34 million.
All right. Thank you. Just let me make some adjustments to the clock here first, okay? Okay, I put another 6 minutes on your time, and so that I can give
So
counsel
you
another
don't
6
take it off
minutes.
my time. Thank you, Your Honor.
All right. Thank
Had
you,
that
counsel.
happen once. May it please the Court, Sylvia Walbolt, my trial counsel, Charlie Ketchy-Beavy. I want to, first of all, make one very important correction, and I want to answer a couple of the questions you asked, and then I want to revert to the documents, the written agreements, sworn agreements that the court entered the judgment on. First of all, counsel said that Mr. May testified that the parties never intended for the release to be enforced, and that is just not correct. The testimony is in the record. He never said that. What he said was that on occasion, when it appeared that it was a proper amount, they paid it. He never said they were not intended to be enforced.
Would that be a waiver to the extent of the payment?
Absolute, to the extent of the payment itself, maybe, but certainly not as to later releases of later work, and that's what they're claiming in this case. And I want to say, because I think it's important, counsel's talked a lot about the course of conduct in the negotiations, and also she mentioned the mediation. I think it's important to know that mediation came after the lawsuit had been filed. There's no evidence in this record that there were any negotiations after the May affidavit, which is what Judge Torpy, I think your question went to. But there's nothing surprising that there would be negotiations during the course of the construction of a multi-million-dollar convention center. A contractor has every incentive not to have problems with their subcontractors, to try to resolve smaller matters that can be resolved, and that can't be said to be a waiver of a later release that is given after all of the work, months after all of the work.
Counsel, let me just tell you one thing that concerns me and ask you about it, and that is, looking at it kind of macro, it seems that there is some allegation out there that the county paid some settlement to the general contractor that included payment for extra work done by the mechanical sub over and above what the mechanical sub was paid for, and that so the net result would be, if the general contractor did not pay the mechanical sub, that the general contractor would have a windfall, that they received money for this extra work from the county, and that maybe even that the subcontractor cooperated in making the claim against the county, but the general contractor didn't pay that money over to the sub. Is that the allegation that the sub intended to raise in the amended pleading?
That is the allegation, and that was the argument made below, but the settlement agreement shows on its face that that's not what the settlement agreement was. The settlement agreement, which is with the county, which has been approved by the county commissioner, shows on its face that it did not allocate any monies for this particular subcontractor's claims. It specifically allocated some monies for 3 other subcontractor claims, but not for this one. It did exactly the opposite. The county said to Hunt, you are going to assume, we're going to make you payment of all these various claims, and you, in consideration of that, are going to assume all liability for these claims. So,
do you think we have jurisdiction to address the issue of whether the trial judge erred in not permitting the amendment of the claim?
I believe so, and it was wrapped into the ultimate judgment that was entered on all of the subcontractor's claims on its complaint against Harper.
Yeah, but the only reason we have jurisdiction with the counterclaim still pending is that the surety is was completely released, and they're a party, and so that was a final order as to the surety. Is it a final order as to the general contractor when there's still that counterclaim pending?
Your Honor, there's not been an issue of jurisdiction been raised, and I'm frank
I raised it.
to say, before you just did,
Yeah.
and I'm frank to say, I need to think about it, and could we perhaps have some supplemental briefing?
All right.
If that would be appropriate. It seemed to me it was a final order, and it just never occurred to me.
Well, if we
until I
need
heard you ask that question.
if we need supplemental briefs, we'll send out an order to that effect. Thank you. You may proceed.
Be happy to do that. Judge Lawson, you asked about the notice issue, and that was a major issue that Hunt raised in its summary judgment. In reply, the subcontractor, Harper, did not point to any written notice that would comply with the contract provisions for a notice of a claim. What the subcontractor said, what Harper said, was that Hunt was on actual notice, that it had certain claims with respect to the change orders that were subject to final reconciliation. It never suggested that Hunt was on notice, even actual notice, of this cardinal change claim that was asserted 3 years into the lawsuit. I'd like, if I could, to revert to the documents, because counsel continually referred to this is a one-page form, and it's true, it is one page, but it's accompanied, before you ever get to this one, by the pay application, which is not just a one-page form, and it's also a sworn statement by the subcontractor, and it certifies under oath through Harper's president, and I'm referring to the February 23 of 04 application, which was well after the work had been completed. All of Harper's work had been completed in the fall of 03. This application certified that all of the work was completed. It specifically referenced change order 29, as counsel says, which was the party's last change order and was a change order for work that had been done before the February pay application. This sworn pay application listed the adjusted contract price to date based on change orders, and specifically encompass of change orders, as being $34.2 million, which was $10 million above the contract price, which was a guaranteed maximum contract price. And that,
But it was not a final price.
it was, by the contract itself, it was to have been a guaranteed maximum.
But the plans were not completed yet, so...
There were change orders of
Right.
more than $10 million, so it was not the final price. The final price was some $10 million over that price. It also listed...
Was change order 29 paid out after this release was effective? As I understand it, the release that you're holding in your hand there, the May release...
No, it was executed before, everything was done before the May release.
When was it paid? When was change order? Was everything paid?
They were paid after the February, I can't give you the date. What I can tell you, it was after the February pay application, because this says there's $1 million due, and that's change order 29.
Okay. And
then in May of 04, Harper, again through its president and again under oath, signs the one-page affidavit, which is under oath. I think that's just incredibly significant. It's under oath, swearing that Harper has received the $1 million payment that was referenced in the pay application, and swearing that it's now been paid in full for all work, including extras and including change orders prior to the date of the pay application.
Let me ask you this. Is there any legal significance in terms of our analysis to the $100 retainage that was left open? I think that there's testimony in the record that that is the normal practice when there are amounts to be adjusted still, if there's money that might still be due. What's the significance of that release document, which purports to end everything with respect to the parties' negotiations and payments and everything, but leaves $100 open?
It left this pay application and the release left the retainage open. It also, Judge Lawson, left open any work that was done after the February pay application. That was specifically excluded, as well as the retainage.
I thought that factually there was no work done after the February pay application. Am I incorrect about that? Was there work still to be done after the February pay application?
Not scheduled work. All of the scheduled work had been completed, but the parties acknowledged or recognized that there always could be some event that the general contractor might have to call the subcontractor back and do some extra work. And so the release specifically excludes any work after the pay application, after the February pay application, and excludes the retainage as well. The release is simply for all work done prior to the February pay application. Okay. Have I answered your question?
Yes.
Yeah, thank you. Sometimes I don't hear very well and I answer questions that aren't asked or don't ask the questions that are asked. This release we submitted, the trial judge correctly found was unambiguous. It uses the broadest language possible, any and all claims. It specifies the work up to a date certain, the date of the last pay application, and says that any and all claims for that work, including extras, including change orders, are being released. And we believe that release should be enforced just as this court has repeatedly enforced releases of any and all claims that relate to a specific matter. In fact, we think this release is even more explicit than the one this court just in the last couple of months enforced in the Spectrum Interiors case, because this release specifically states on its face that it includes, quote, extras and all change orders to the date hereof. And that language just cannot be construed to mean not any and all claims, but rather some claims. And there have been numerous courts, we've cited them in our brief, that have enforced this precise release language. The cases that HARPER has relied on, where they found issues of fact, and even then they didn't nullify the release, which is what HARPER seeks. Even then they enforced it in part, but just found there was some ambiguity in language that does not appear in our case. And because this release language is so clear and is unambiguous, this court should never get to extrinsic evidence. It should never get to course of performance. And that's what this court specifically held in Spectrum, that when it's unambiguous, you don't look outside the contract. Counsel cited the Lake Sioux case, and I think that really makes the point. In Lake Sioux, there was a contract that specifically provided it could be extended. And the question was, had the parties extended the contract? And so they introduced extrinsic evidence to see whether the parties had extended the contract. And that's just not what we have here. Here, HARPER doesn't point to any language in this release that it says is ambiguous. It just says you should admit extrinsic evidence to interpret the party's intent. And if you do that, Your Honors, then the exception swallows the whole. Then you always are admitting extrinsic evidence to show the party's intent. And the law is just clear beyond any dispute that that is not the law. And I just want to make one point.
Well, if you change vary the terms of this particular release, you might as well shred it, right? Because it has no purpose other than to exchange payment for a complete release of any claims, right?
Your Honor, it had far more purpose than just that. A part of the purpose of this is to have an orderly progression so that not just the general contractor, the construction manager, knows how much has been spent and how much is owing, but that the owner does. And this goes to the notice requirements that Judge Lawson alluded to. You have these steps, and they're clearly and succinctly set out in the contracts so that everybody knows as the construction proceeds how much is being owed, how much is being claimed, and there's a place on the pay application to specifically say
They did pay change orders, though, that they were not legally obligated to pay throughout the performance of the job. Is that right? Your client
That's
did.
correct. They had an obligation to pay only if there was this release and orderly pay applications. Otherwise, they had no obligation to make progress payments.
No, but I mean, they made payments on change orders after the work had been released, after the payment had been released.
In some instances, they did, Your Honor.
Mm-hmm.
And again, I would say that can't, whether that's a release or a waiver of the payments for that particular work that was earlier done is a different issue than the issue that's being asserted here. Here they're saying that because you made these payments, you resolved these issues on earlier types of work, that waives your right to rely on a release that relates to later work where you don't contend that or don't agree that you have any monies due and owing, and you can't use prior conduct to modify a subsequent release. And I would say, Your Honor, you particularly cannot do it when it is a release that is given months after all of the work has been done, months after the last pay application, months after the last change order, and does not accept or reserve any claims made, no notice in accordance with the contract. All of the course of conduct that they're relying on occurred prior to that May affidavit, and the trial court quite properly enforced that release. Thank you, Your Honor.
All right, thank you.
If I may briefly respond. As a preliminary matter, you asked me about the notice of claim and whether we filed an official notice under the trade contract agreement. It was our position throughout that these were simply extra costs that incurred as a result of the work we were doing. This was the increase in our cost in trying to comply. It wasn't an additional claim. It's not as if we were the mechanical subcontractor and then we were asked to do other work that we never agreed to and we were asserting a different claim. This was doing our work on the project subject to some change orders, and we were just...
I have a hard time seeing a cardinal change claim as not being an additional claim to...
Your Honor, that was pled in the alternative because it was being asserted that the argument was that the one-page document that I keep holding up did away with the trade contract. So the cardinal change document, and I wasn't trial counsel, but this is my understanding of why Mr. Fussell did it this way. The cardinal change was brought up as an alternative to the breach of contract. We were attempting to enforce the contract. But there was a suggestion, that contract didn't matter anymore because we had executed this release. So it was brought up alternatively. But what we were trying to get compensated for, and I want to direct the court to the appendix at page 38. And this is the testimony of Bob May again. I keep bringing him up. But he was asked about a letter he wrote to the county. And it says... he wrote an email, and it says, both Harper and Curlin have some serious cash flow problems on this job because of the numerous and substantial revisions issued and the fact that they have performed significant amounts of additional work without change orders being approved or executed. We agreed that you would fund three out of your contingency for payment for additional work performed by Harper to date. I would also like to draw the court's attention...
What was the date of that correspondence?
This email exchange, I don't have the actual date of that one, but it was when they were throughout the project. It was throughout the project trying to get more money from Orange County to pay as they were going along.
I mean, didn't they, to the extent of $10 million, get extra money to pay for the extra work
right,
throughout
and
the
then
project?
afterwards they paid $14.2 million. And there's a suggestion that the settlement agreement is vague. I would like to draw the court's attention to page 161 of the appendix, and there's an email exchange between the lawyers negotiating. It's Lilburn, Rayburn, and Kevin Knight, and it says, Lilburn, we wanted to update you on the status of various subcontractor and prime contractor claims after last week's meeting between county representatives and Hunt representatives. And they go down and they list, and it says, in particular, HCC and the county have generally discussed the fact that the following claims could be resolved for the following numbers. HCC, $2.6 million. Sunshine Roofing, $500,000. JCI, $2.5 million. Keenan Mater, $1.5. It was a settlement. And then mechanical proposed settlement. Harper Curlin, $14.7. So it is clear that Harper's requests for additional payments to make up for all the extra work we did and our costs on this were completely compensated or contemplated in the settlement with Orange County. This wasn't a bunch of other subs trying to get the 14 or entitled to the $14 million. That was Harper. And as a final note, because I see that
let me ask you this: what is your independent legal theory? Just suppose, for sake of argument, that summary judgment was proper as to the matters that were originally pled. What is the legal theory? I mean, constructive trust is generally a remedy, not a legal theory. What legal theory would you propose to get money that you think was negotiated?
It was a right to assert the settlement proceeds, because those monies were paid to Harper to pay us.
Yeah, but what gives you a legal right to get that money?
Because
Try unjust enrichment.
well, quantum merit, unjust enrichment,
but you
all
didn't
of those.
you didn't ever plead that or attempt to amend to plead those theories.
I think that's what Mr. Fussell thought he was conveying, because constructive trust is equitable and unjust enrichment is equitable. If he didn't word it as nicely as he could have, I'm sure it will be corrected when you hopefully reverse this, because there are clearly issues of fact here. This discussion that we've gotten into today, if this doesn't demonstrate that summary judgment was inappropriate.
I think you answered Judge Lawson's question.
Thank you.
Thank you.
Do you wish us to submit some
If we do, we will ask you in writing to do that. Thank you. Well argued case. Thank you. Court of